They built 96 homes on land that belonged to my family, not adjacent to it, not partially overlapping it, on it. 341 acres of bottomland and Pine Ridge in southeastern Georgia that my great-grandmother Celia purchased in 1923 with money she had saved across 11 years of domestic work. Money she kept in a tin box under a floorboard because no bank in Ware County would open an account for a black woman in 1923, and that she recorded at the county courthouse herself on a Tuesday morning in October by walking to the window and placing the deed in front of the clerk, who did not look at her while he stamped it, but stamped it anyway because the law required him to, and Celia Drummond understood the law better than most people gave her credit for. The development was called Pineview Estates. It had been built between 2004 and 2011 by a company called Coastal Georgia Development Partners. It had an HOA with a management office and a pool, and a community events calendar and monthly dues of $380 that 96 families had been paying for between 3 and 17 years, by the time I walked into Ware County Superior Court with 4 attorneys and 112 years of documented property records. My name is Josephine Drummond Reese. I am 49 years old. I am a property rights attorney. I specialize in heir property cases, partition actions, and the specific category of land loss that occurred across the American South between 1900 and 1980, when black-owned land was taken through tax sales, fraudulent deeds, legal manipulation, and the simple arithmetic of recording offices that filed things incorrectly when the owner was someone they did not expect to see come back with documentation. I have been working these cases for 21 years. I knew what I had when I found Celia's deed in my grandmother's cedar chest in 2019. I knew what it would take to establish it, and I knew that the most important decision I would make in the entire process was deciding when to speak. Comment below where you are watching from. Because this story ends with a judgment that restructured the ownership of 341 acres in southeastern Georgia, a development company that ceased to exist before the verdict was entered, and 96 families who learned simultaneously that the land their home sat on had never legally belonged to the people who sold it to them. But it begins with a tin box and a Tuesday morning in 1923, and a woman who understood that the paper you hold is only as strong as your willingness to defend it. Celia Drummond was born in 1889 in Ware County, Georgia. She worked as a domestic worker for the Haverford family in Waycross from 1908 until 1921, saving money across those 13 years at a rate that required a discipline I cannot fully imagine, and that her granddaughter, my grandmother Estelle, described as the kind of saving that means you eat what is left and wear what holds together and put everything else in the tin. In 1922, Celia began negotiating for the purchase of 341 acres of bottomland and Pine Ridge in the southeastern portion of Ware County from the estate of a man named Harlan Pruitt, who had died without direct heirs, and whose land was being sold by an estate administrator named Gideon Cross. The negotiation took 14 months. The price was $1,200. Celia paid it in cash, from the tin box, in 3 installments across 1922 and 1923. The deed was recorded at the Ware County Courthouse on October 14, 1923, in Deed Book 47, page 312. I have the original. I have a certified copy from the county recorder. I have photographs of the courthouse record taken in 2019 on the day I found the deed and drove directly to the courthouse to verify the recording before I said a single word to anyone. Celia farmed the land. She raised 4 children on it. Her husband Ezra, whom she married in 1926, built the farmhouse that stood until 1971 when my grandmother Estelle, Celia's youngest daughter, had it properly reconstructed on the same foundation. Celia died in 1954. The land passed to her 4 children through a will that Celia had drafted with the assistance of a Waycross attorney in 1948, and that was probated in Ware County in 1954 without difficulty. The 4 children, Estelle, Robert, Mamie, and Calvin owned the land jointly. This is where the heir property problem began, though none of them knew it at the time. Heir property, for those who are not familiar with the term, is land held by multiple heirs without a formal legal partition or clear title instrument establishing each heir's specific interest. It was and remains enormously common in black communities across the American South because the legal mechanisms for formalizing joint ownership were expensive, required attorneys who were not always accessible, and were frequently not completed across generations. The Drummond land passed from Celia's 4 children to their children and grandchildren through a combination of informal agreements, shared use, and the kind of family understanding that works perfectly well until it encounters a legal system that requires documentation. By 1980, the land was claimed by interests descending from all 4 of Celia's children. Robert had moved to Detroit in 1961, and his children had varying levels of connection to the property. Calvin had died in 1969 and his wife had remarried and moved away. Mamie's descendants were mostly in Jacksonville. Estelle, my grandmother, had stayed on the land her entire life, maintained it, paid the property taxes, and understood herself to be its primary steward even though the legal title situation was, by 1980, genuinely complex. My grandmother, Estelle, died in 2003. She left a will that attempted to consolidate the family's interest in the property and leave it to her children, of whom my mother was one. The will was probated in Ware County, but the probate did not and could not resolve the underlying heir property complexity, because resolving that would have required identifying and joining all interests descending from all 4 of Celia's children, some of whom were not in contact with the Georgia branch of the family. My mother inherited Estelle's claimed interest. She was not a lawyer. She did not know the title situation was complex in ways that created vulnerability. She paid the property taxes. She visited the land. She thought of it as Celia's land, which it was, and as the family's land, which it was, and she did not know that in 2001, 2 years before my grandmother died, something had happened to the property records at the Ware County Courthouse that would take me 18 years to find and understand. In 2001, a deed was recorded in Ware County that purported to transfer 341 acres of bottomland and Pine Ridge in southeastern Ware County from the Drummond Family Trust to a land holding company called Southeast Georgia Land Acquisitions, LLC. The Drummond Family Trust did not exist. There was no Drummond Family Trust. No trust had ever been created. No trust instrument had ever been filed. No trustee had ever been named. The deed was a fabrication. The signature on it, purporting to represent the trustee of the non-existent Drummond Family Trust, was not a Drummond family member's signature. The notarization on it was from a notary public in Brantley County who, when investigators later spoke to her, had no memory of the transaction and whose notary stamp had reportedly been stolen from her office sometime in 2000 or 2001. Southeast Georgia Land Acquisitions, LLC had purchased nothing from nobody because nobody with authority to sell had signed anything. But the deed was recorded. It sat in the Ware County Deed Records in Deed Book 312, page 88, and the recording gave it a presumption of validity that required active legal challenge to overcome, and nobody challenged it for 3 years because nobody in the Drummond family knew it existed. Southeast Georgia Land Acquisitions, LLC sold the land to Coastal Georgia Development Partners in 2003 for $2,400,000. Coastal Georgia Development Partners broke ground on Pineview Estates in 2004. The first home sold in 2005. By 2011, 96 homes had been built, occupied, mortgaged, and in many cases refinanced and resold in normal residential real estate transactions. Every single one of those transactions rested on a chain of title that included a fraudulent 2001 deed. Every title search conducted for every one of those transactions should have found Celia's 1923 deed, and the absence of any valid instrument connecting the Drummond family's ownership to Southeast Georgia Land Acquisitions. Some title searches apparently did find it and concluded that the 2001 deed resolved the chain, perhaps on the theory that it represented a trust instrument formalizing the heir property situation. Some apparently missed it. All of the title insurance policies written for these properties insured over the encumbrance without flagging it as the existential title defect it actually was. I found Celia's deed in November 2019. My mother had died in 2017, and I was going through the cedar chest my grandmother Estelle had kept, the one that held documents she considered important enough to protect. The deed was in an envelope that also contained the original purchase receipt signed by Gideon Cross, the estate administrator, and a letter from the Waycross attorney who had drafted Celia's will in 1948, advising her that the deed was clear and that the property was hers and her heirs, without encumbrance. I photographed both sides of the deed before I touched anything else. I drove to the Ware County Courthouse that afternoon. I found the 1923 recording in Deed Book 47, page 312, exactly where it should be. I photographed it. Then I searched forward through the deed records for every subsequent instrument affecting the parcel. I found the 2001 deed in Deed Book 312, page 88. I read it 3 times in the courthouse. Then I went to my car and sat for a while. I had been practicing property rights law for 17 years at that point. I had handled 41 heir property cases across Georgia, Alabama, and South Carolina. I had seen fraudulent deeds. I had seen tax sale abuses. I had seen partition actions that had been used to strip black families of land they had owned for generations. I knew exactly what I was looking at in Deed Book 312, page 88. And I knew that what came next was going to require the kind of patience and precision that Celia Drummond had applied to saving $1,200 across 11 years of domestic work. I drove home and told nobody. The first thing I did was hire a title research firm that was not connected to any party with an interest in the Ware County property. I used a firm in Savannah that I had worked with on previous cases and whose principal had 28 years of experience in Georgia property records research. I asked for a complete chain of title going back to the original land grant for the 341 acres, forward through every recorded instrument to the present. I told the principal I needed everything and I needed it without any communication to any party other than me. She understood. The research took 11 weeks. The report she produced was 412 pages covering 112 years of title history. Every deed, every tax record, every court filing, every lien, every satisfaction. Every probate instrument touching the 341 acres from the original Prout estate through Celia's purchase, through the Drummond family stewardship, through the 2001 fraudulent deed, through the 2003 sale through Coastal Georgia's development, and the subsequent 96 individual property transactions. The report confirmed what I had seen in the courthouse. Celia's 1923 deed was valid. It was recorded. It was the root of title for the Drummond family. Every subsequent Drummond family instrument was traceable to it. The 2001 deed was not. The Drummond family trust did not appear in any prior instrument. No trust had been created. The grantor on the 2001 deed had no authority to convey. The deed was void, not voidable, void, meaning it conveyed nothing, regardless of what subsequent transactions had relied upon it. A void deed under Georgia law does not become valid through reliance or through subsequent recording of additional instruments. It remains void. And a void deed in the chain of title means every transaction downstream of it rests on nothing. The second thing I did was identify every Drummond heir with a potential interest in the property. This took 8 months of genealogical research, family interviews, and records tracing. Celia's 4 children had produced, across 3 generations, 22 individuals with a traceable interest in the property under Georgia's heir property framework. Some of them were in Georgia. Several were in other states. 2 required locating through genealogical database work. All of them needed to understand what existed and what was at stake before I could proceed. These conversations were the part of the work that required the most care. I was talking to people who had varying levels of knowledge about the family land, varying levels of connection to it, and varying levels of interest in pursuing a legal process that I had to describe honestly as lengthy, uncertain in some respects, and emotionally complex given what it would mean for 96 families who were not the people who had committed the fraud. I told every cousin, every aunt, every descended heir the same things: that Celia's deed was valid and recorded, that the 2001 deed was fraudulent and void, that the Drummond family had a legally cognizable claim to the land that supported the development currently on it, that establishing that claim fully would require litigation that could take years, that the outcome of litigation would not necessarily mean 96 families lost their homes, because the legal resolution of a title dispute of this kind had multiple possible forms, including monetary resolution, lease arrangements, and negotiated purchase by the current occupants of their lots, and that moving forward required the agreement of the family, not just some of the family. 20 of 22 heirs agreed to move forward. The other two were located but declined to participate, which was their right. Their non-participation complicated but did not prevent the legal action because, under Georgia law, a sufficient number of heirs could proceed with a claim representing the family's collective interest, with the non-participating heirs' shares to be held in trust pending their future engagement. The third thing I did was build the fraudulent deed investigation. I was not conducting a criminal investigation. That was for law enforcement. But I needed to understand the fraud completely before I filed anything, because understanding the fraud was essential to establishing that the 2001 deed was void rather than merely voidable. Voidable deeds can sometimes be ratified by subsequent conduct. Void deeds cannot. My argument that the deed was void rested on the non-existence of the Drummond family trust and the absence of any signatory with authority to convey. I needed to be certain that no trust had ever existed, that no family member had authorized the transaction, and that the notarization was fraudulent. The notary stamp research took 6 months through investigative channels. The notary in Brantley County confirmed her stamp had been misused and provided a sworn statement. No Drummond family member had any knowledge of or participation in the 2001 deed. I had sworn statements from every heir I had located. The Drummond Family Trust had never been filed with any Georgia court, never registered as a trust entity, never been the subject of any legal instrument that preceded the fraudulent deed. The people behind Southeast Georgia Land Acquisitions, LLC, were identified through corporate records research, subpoenaed business records in related proceedings, and the investigative work of a firm I retained in 2020. The principals had dissolved the LLC in 2009. One had died. 2 others were located in Florida and were subjects of a separate criminal referral I made to the Georgia Attorney General's office in 2021. The criminal case was separate from the civil action and moved on its own timeline. I filed the civil action in Ware County Superior Court in March 2022. The complaint named Coastal Georgia Development Partners, its principals, its successor entities, and the title insurance companies that had issued policies on the Pineview Estates properties. It did not name the individual homeowners as defendants. This was a deliberate and carefully considered decision. The 96 families in Pineview Estates had purchased their homes in good faith. They had relied on title insurance. They had done nothing wrong. They were not the people who had committed or benefited from the fraud. The legal action was directed at the entities whose negligence or wrongdoing had created the situation, not at the people living in its consequences. The complaint sought a declaration that the 2001 deed was void, a declaration that the Drummond family held valid title to the underlying land, an accounting of all proceeds received by the development and related entities from the development and sale of properties on the land, damages representing the value of the land, the development profits, and the ongoing use of the property. An injunctive relief requiring the title insurance companies to honor their policies to the individual homeowners. I filed the complaint on a Tuesday morning. Then I called the Pineview Estates HOA board, not to tell them what was in the filing, to tell them a filing had been made that affected the title to all properties in the development and that they should retain legal counsel immediately. I gave them the case number and the court. Then I let the court process do what court processes do, which is move at the speed of a system designed for thoroughness rather than urgency. The Pineview Estates HOA board retained a Waycross attorney named Gerald Odom within 48 hours of my call. Gerald had been practicing real estate law in Ware County for 31 years and had the specific quality of experience that comes from having handled every kind of property dispute the region produced, which meant he understood within 2 days of reading the filing what it contained and what it meant. He called me on a Thursday. "Ms. Drummondrees," he said, "I have read your complaint and the supporting title research. I want to have a direct conversation." I said I was available for direct conversation. He said, "The 1923 deed is valid and recorded." Yes. "The 2001 deed is fraudulent on its face." That is our position, and we have the evidence to support it. He was quiet for a moment. "My clients," he said, "are 96 families who bought homes in good faith." "I know that," I said. "Your complaint does not name them as defendants." "Correct. The action is against the entities responsible for the fraudulent conveyance and the development built on it." He said, "What outcome are you seeking for the land itself?" This was the question I had been preparing to answer for 3 years. I said, "The Drummond family's primary interest is recognition of their ownership of the underlying land and fair compensation for 341 acres of bottomland and Pine Ridge in Ware County, Georgia, that was fraudulently taken from them and developed without their knowledge or consent. We are not seeking to displace 96 families from their homes. We are seeking the economic value of what was taken and a legal structure that recognizes the family's rights going forward." "What does that look like in practice?" I said, "Several structures are possible. The families could purchase the underlying land at fair market value through a negotiated process. The title insurance companies could fund the compensation to the Drummond family, which is what title insurance is designed to do when title fails. A combination of development company assets, title insurance proceeds, and negotiated arrangements with individual homeowners could fund a comprehensive resolution. The goal is not to tear down 96 houses. The goal is for Celia Drummond's family to receive what Celia Drummond paid for and what the law protected for 100 years before someone filed a fraudulent piece of paper in Deed Book 312. Gerald was quiet for a long time. He said, "I am going to recommend to my clients that they cooperate with this proceeding and pursue resolution through their title insurance policies." I said that was the right recommendation. The litigation proceeded through 2022 and 2023. Coastal Georgia Development Partners had formally dissolved in 2018, but its principals were named individually, and their insurance coverage was pursued through multiple carriers. The title insurance companies were the primary source of meaningful recovery because they had the resources and the contractual obligation. Their defense was that their policies insured the individual homeowners against title failure and that the proper remedy was for the homeowners to claim under those policies, which would then subrogate the insurers into the litigation against the development company and its principals. This was the correct legal framework, and it was the one I had anticipated when I designed the litigation strategy. The individual homeowners filed title insurance claims, all 96 of them. Title insurance companies, faced with 96 simultaneous claims on policies that covered the full value of each home, had every incentive to reach a comprehensive resolution rather than litigate each claim individually. The mediation process began in early 2023. I represented the Drummond family. Gerald Odom represented the HOA, and by coordination, the interests of the individual homeowners. 4 title insurance carriers were represented by their own counsel. The development company principals were represented individually. The mediation was conducted by a retired Georgia Court of Appeals judge named Patricia Hollies, who had spent 3 years on the bench and 20 before that as a commercial litigator. and who approached the process with the organized patience of someone who had seen complicated disputes and understood that complicated disputes resolved themselves when the parties understood their actual positions clearly. The Drummond family's position was clear. The 1923 deed was valid. The 2001 deed was void. The family was owed the value of 341 acres of developed Georgia bottomland and Pine Ridge. Current appraised value of the underlying land, excluding improvements, was $4,200,000. The development profits from the original construction and sale of 96 homes, documented through the development company's records obtained in discovery, had been $11,800,000. The ongoing use of the land since 2004 represented a continuing trespass for which damages were cognizable. The family's demand was $8 million, not $11 million, not the full development profit. $8 million, representing the land value with a reasonable multiple for the fraudulent conversion and the family's inability to use the land for 21 years. The title insurance carrier's position was that their maximum exposure was the aggregate policy limits on 96 homes, which totaled approximately $47 million in insured value, but which they were not going to pay in full because the policies had deductibles, coverage limitations, and subrogation rights that affected the net amount. What they wanted was a number that resolved all claims simultaneously, cleared the title for the homeowners, and gave them a clean subrogation path against the development company principals. The development company principals had assets, not enough to satisfy the full judgment, but enough to contribute meaningfully with their insurance coverage included. The mediation ran for 4 sessions across 6 weeks. The final resolution, reached in September 2023, contained the following elements. The Drummond family received $7,600,000 in total compensation, $5,200,000 from the title insurance carriers as part of a global settlement that simultaneously resolved all homeowner claims, $2,400,000 from the development company principals and their professional liability carriers. The individual homeowners received clear title to their properties through a legal instrument that extinguished the Drummond family's claim on the specific lots and structures, while preserving the family's right to the unimproved portions of the original 341 acres that had not been built on. Those unimproved portions, totaling approximately 62 acres of Pine Ridge at the eastern edge of the original parcel, were returned to the Drummond family's direct ownership through a deed executed as part of the settlement. The HOA was restructured to include a maintenance obligation for the boundary area adjacent to the Drummond family's 62 acres, with specific terms ensuring access and protection. The criminal referral I had made to the Georgia Attorney General produced separate proceedings against the 2 surviving principals of Southeast Georgia Land Acquisitions, LLC. Those proceedings were ongoing at the time the civil settlement was reached and were not part of the civil resolution. The Drummond family gathered on Celia's land in October 2023. Not all 22 heirs were there. Some had distances too great, but 14 came. We stood on the 62 acres of Pine Ridge that the settlement had returned to direct family ownership, on the eastern edge of the property that Celia Drummond had walked from the courthouse in 1923 with a stamped deed in her hand. The pine trees on that ridge were not the same trees Celia had walked under, but they were on the same ground. My grandmother Estelle had walked that ridge. My mother had walked it. I had walked it as a child visiting my grandmother, not knowing what the ground was, knowing only that it was ours in the way that some places are yours before you understand what yours means. A cousin named Marcus, who had flown in from Detroit where his grandfather Robert had moved in 1961, stood at the edge of the ridge looking south toward the development whose roof lines were visible through the trees. He said, "What do we do with 62 acres?" I said what Celia did with 341, we keep it. He looked at the trees. He said she walked into a courthouse in 1923 and put a deed in front of a clerk who would not look at her. I know. He said, and the deed held. Yes, I said, it held for 100 years, through everything. Through the tin box and the fraudulent conveyance and the development and the HOA and the 96 families and the mediation and the title insurance carriers and the 4 attorneys and the retired Court of Appeals judge. It held. Marcus was quiet for a while. Then he said she knew it would. That was why she recorded it. She understood that the paper you hold is only as strong as your willingness to defend it. I know, I said. That is why she kept the receipt. That is why she kept the attorney's letter. That is why my grandmother kept the cedar chest. And that is why I drove to the courthouse the day I found it and did not say a word to anyone until I understood everything I was holding. We stood on the ridge until the light went. Then we drove back to the house my grandmother had rebuilt on Celia's original foundation, where the family had made food and there was too much of it, and the conversation was loud and went late into the evening the way family conversations do when they have been carrying something heavy for a long time and have finally been allowed to set it down. If you have inherited land and do not know the exact legal status of its title, find the deed. Go to the county recorder. Read the chain of title yourself or hire someone to read it for you. Heir property is vulnerable in ways that valid recorded title is not. Formalizing your family's ownership through a legal partition or a clear title instrument is not bureaucratic housekeeping. It is the thing that makes the paper hold. Hit the like button if you believe Celia Drummond deserved to have her deed defended. Subscribe for more stories about property, rights, documentation, and the long patience of people who understood that what you record correctly can outlast everything that is done to take it from you. And if you know someone whose family land has a complicated title history, send them this. Because the cedar chest in your grandmother's house may contain the most important document you have never read. Framed thumbnail text. Built 96 homes on MY family's land. Subtext stayed silent until court day.